My name is Julius Brecht. I'm an attorney in private practice here in Anchorage. I've been in an attorney for going on almost 50 years. Prior to that, I worked for NASA for several years. I was actually an astrophysicist with NASA during the time of the Apollo missions. And so I switched from, I succumbed to the common law and switched from the natural law to the common law. So that being, that's kind of a thumbnail sketch of who I am. I also have two sons here in Anchorage, when married, and wife and two sons. One of whom, the sons, is still in Anchorage, and the other one is back east. He's a medical doctor. The one here, that brings me to what does of counsel mean? Well, it means basically I come and go as I please within the law firm. My name is in the masthead, but again, but it's not because of me, it's because of my son, Christopher Brecht, who is a shareholder in Bankston, Groning, and Brecht. So that all being said, I've gotten kind of in a rut in that I've given many presentations here in town through the years, but kind of stuck on A for astronomy. It's harking back to my times in NASA, and before that, I've been a long time amateur astronomer. But so I'm grudgingly going forward to C in the alphabet to talk a little bit about the Corporate Transparency Act. And for those of you who are here, there are handouts that you can have to show that'll cover what I'm going to be talking about today. Okay, so I'm an attorney. I have to give you the standard disclosure. I don't represent any of you. None of you are my clients in the context of what I'm going to be saying here. Basically, I'm giving you some of my thoughts about some of the provisions of the Corporate Transparency Act and regulations that have been adopted pursuant to that act. And also, for those of you who are interested, how I got started on this was I kind of backed into the topic in the sense that I heard about it first in March of or thereabouts of this year, and I thought, geez, this really strikes me as being a significant change to securities law. And maybe it wasn't intended, maybe it was, I don't know, but it does, and that's my focus of practice is securities law, small business issues. So anyway, it kept bothering me, so I started putting pen to paper, and what evolved out of that was an article that presently appears in the Alaska Bar Association, Alaska Bar Rag, for those of you who may have access to it. I understand that some of you may have gotten a copy of the article through Kai Holland, who sent it out several days ago at my with my permission. So that's the kind of the preliminary statement. So the new corporate reporting just around the corner. What does all this mean? Well, hopefully in the next few minutes, I'll be able to give you an idea of what it may be facing you as a small business or startup entrepreneur. On the surface, CTA appears admirable in its purpose. It states in the statute that it's to combat money laundering in the U.S. and to establish a database of information to support that effort. But to attempt to do so, and in setting up this database, it will cause small business, either startups or persons involved in small business ongoing, to provide what will be required to provide certain personal information on themselves, as well as the entity involved. And we'll get, as we get into this a little more, you'll be able to tell you what that means. Okay, next slide. Corporate Transparency Act, stated purpose, data bank, beneficial owners to combat money laundering. It's found in the U.S. Code as shown in the slide. It was enacted in 2021, right at the height of COVID. I'll just leave it at that. It has an effective, it was effective January 1, 2021, and it is administered by an outfit called the Financial Crimes Enforcement Network, FinCEN, within the U.S. Department of Treasury. That's your U.S. Department of Treasury, same department that houses the IRS. The IRS, if you didn't hear that. Okay. Personal information, IRS, FinCEN. Keep those in mind. Okay, so next slide. Now you might say, wait a minute, what's money laundering? Maybe we're jumping into this and not explaining some of the basics. Well, a generic definition of money laundering is the concealment of the origins of illegal obtained money, typically by means of transfers involving legitimate businesses or foreign banks, also local banks. It doesn't have to just be a foreign bank. The process typically takes place in 3 steps. First, there's the placement of the illicit funds to enter into the legal economy in some fashion, and it may take place through business or small cash deposits to avoid appearance. Second is layering. The illicit funds are separated from their source. It's moved around maybe many times, many steps, many entities, possibly even many countries. Depends on how sophisticated you want to become. And third, the final step is integration. The illicit funds are effectively cleansed. They are no longer illegitimate. They are legitimate funds that can be used for legitimate purposes. Next slide. Okay, so examples of how money laundering can occur are smurfing, or something called smurfing or restructuring, where the criminal splits up a large sum of illicit funds into many smaller amounts and then gets them into to the economy, maybe into a bank account, keeping in mind that if you put in, if there's a transaction involving $10,000 or more, the bank or the financial institution has to report it. So the money launderers are aware of that, and they try to keep the amount just less than that 10,000 figure. Okay, the next one is cryptocurrency. We're going off the slide here. Is this what's happening? Maybe we got to move the camera closer, or projector.
No, it's the slide itself. Yeah. It's the letters are coming off the bottom.
All right. So that's just the very bottom. Okay. Yeah, you're right. It's just going right to the edge of the slide. Okay, so smurfing or restructuring. Cryptocurrency is another way that you might try to get the monies into the legitimate economy. It's an unregulated route, and it makes a potential for a vehicle for money laundering. Next slide. And then there's trade-based, using a complexity of international laws and regulations to move money around, to change in invoices, the value of goods, and a lot of different ways of doing it. Online gambling. This is one that kind of blows my mind. You have one accomplice at a digital table loses on purpose to another accomplice on the digital table, and you quietly move illegitimate funds into legitimate, to another place where they become legitimate funds. And then finally, reselling of assets. Criminal purchases big ticket items. You could buy a fancy car, fancy boat, real estate, and with the illegitimate funds, and then immediately turn around and resell it, the item for, and get legitimate funds, which can then be put into a legitimate bank account and be treated as a legitimate funds. In each of the above schemes, the illicit funds emerge as clean and legitimate. They have been laundered and can be used like any other funds, legitimate funds. Okay, next slide. Okay, so back to CTA. Those who must report. This is where you got to kind of watch the bouncing ball, because there's an intricacy of this statute that you might not at first pick up on. But we start with entities that are created by filing registration with a state or an Indian tribe, or formed under a law of a foreign country and registered to do business in the U.S. Now think for a moment what that means. And I'm going to, for the rest of my presentation, I'm going to be focusing on filings with the state, not with a tribe, not with doing business. And we can, that put that off to another presentation if you like. But what's going on here? Go back. Okay, that's all right. All right, so okay, so filing registration with a state. What does that mean? Well, when you incorporate, you have to file papers. You have to file a document with the state. You do it online, or you do it by snail mail. You have to file something with the state court. And the state comes back and is a part of the process of creation of that entity. The state issues a certificate of incorporation. That's what the entity that, or the instrument, the document that makes the entity have real existence. Could be a limited liability company, could be a limited liability partnership. Probably is not a general partnership, because there's no need to file a document with the state to become a general partnership. So you got to sort that out as to what your business structure is, as to whether it trips the wire of being created by a filing of a registration with a state, meaning state of Alaska in our case, or any of the other 50 states or territories of the U.S. Guam, Virgin Islands, so forth. Next slide. Okay, so what is this information that has to be filed? Beneficial information? Well, on its surface, it seems innocuous enough. It's the business name, the current address, state of formation, tax ID, employer ID, same as what the IRS uses. And as to each beneficial owner, the full legal name, birth date, current address, and government-issued photo ID. That's going off the slide again. Driver's license or passport. Now think about that. That's getting pretty basic stuff for each beneficial owner. And of course, backing into securities raises the question whether that prospective beneficial owner in a securities offering wants to have that information disclosed. And it doesn't. I should also point out that it doesn't have to be ownership of stock, for example, to 25% of the stock of the company. It can be that you influence at least 25%, that you have the influence to cause a change of management in the context of the securities, the senior officers of the company, and or the board of directors of the company, if you have a board. And what I'm saying about a company, when I slip into jargon for corporations, it applies to other business entities that might be formed like an LLC, where you don't necessarily have a board of directors, don't necessarily have executive officers, but you do have an entity that requires filing with the state in order to get creation of that entity. So anyway, that's the beneficial information that has to be filed. Next slide. Okay, the act is something like about, I don't know, 15 or so, 20 pages in length. The regulations are about 2 or 3 times that. They were adopted on September 30, 2022. And they are all found in the Federal Register, and they become effective on, this is an important date, January 1, 2024. Well, you say, why such a long time frame? It's not really, there's no explanation given, but this all triggers on January 1, 2024. That's less than 6 months from today. Okay, so next slide. Beneficial owner. Okay, this is the key, another key that you have to keep in mind. It's defined as as owns or controls not less than 25% of the ownership interest. That's what I was saying just a moment ago, that it doesn't necessarily mean ownership of 25% of the stock. It could mean that you have maybe a side agreement that you can control the executive officer's selection and or the board of directors, the senior management of the entity. Next slide. Oh, I should also point out, as I'm going through this, if there are questions, we can either take them up at the time, and we can stop and take questions, or we can take all the questions at the end. But either way, I know there's a lot of information, and I don't want the people to get overwhelmed by the complexity of what's going on here. All right, so I've talked a lot about the difficult parts of the act to what it applies. There are some exemptions. There are 23 in number under limited conditions in each case. They include banks, credit unions, both of which should have to be insured through deposits insured through federal insurance, FDIC insurance, or in case of a bank. Insurance companies, which are typically formed by state law. Public accounting firms. Now, I don't know why they give the public accounting firms a free ride, but they don't give the lawyers a ride. But that's another side story. And also such things as reporting companies under the Securities Exchange Act of 1934. If you're on NYSE, NASDAQ, a company like that, a very large company, obviously, then you are not subject to the reporting requirements under this act. There is one exemption that might help you as a small business, and that's an entity with more than 20 employees, and you had can demonstrate through tax filings from the previous year that you had more than $5 million in gross receipts or sales. Typical startup is not going to fit that, so you're stuck. And you must have an operating presence in the at a physical office within the U.S. Okay, 23 of them. The CTA allows the Secretary of the Treasury by regulation to add other exemptions. And the last time I checked, within the past few days, they still had not added any additional exemptions. Next slide. Okay, risk factors. Okay, I mentioned this a little bit before. To me, the way I got and became aware of this in March, I started thinking about it in terms of securities offerings for a startup company or for recapitalization of a company. That the risk of becoming a beneficial owner is a risk factor that would have to be included. It's a material term. Again, I'm not advising you on this, but it's just my thought that I think is going to be hard to avoid that being a risk factor in your securities offering, whether it be private or public offering. And what does that require? That means disclosure of the risk itself and the material facts relating to the beneficial ownership, reporting requirements, penalties for non-compliance with CTA, invasion of personal privacy of a beneficial owner. Think about this. Let's say you have this typical startup and you're looking for some sugar daddies. You're looking for somebody that has some big bucks they're going to put in, and maybe one of those persons would actually acquire more than 25% of the ownership. They become a beneficial owner, and they immediately, the entity must file as a part of that process, file with FinCEN to avoid the penalty provisions of the act, which we'll get into in just a moment. It could also happen if you, let's say you as a prospective investor maybe acquire some modest amount of the securities, 5%, 10%, something like that. But later acquire others of the securities from other than the shareholders and bump up against that 25%. That's going to trigger a filing requirement with FinCEN. So you're not out of the, you're not out of the woods just because you didn't have 25% to start off with. Okay, next slide. Reporting accuracy. Oh, something else, a little hook in this is that not only the entity must file information, but those persons that are involved in the filing of the and seeking the registration, the creation of the entity on and dealing with the state. For example, maybe the secretary of the president, or maybe the attorney for the company. You'd have to provide personal information on that individual, the same as you would for a beneficial owner. Okay, other trigger reporting triggers. I said this a little bit before, but updates to beneficial ownership, beneficial information. For example, what if one of the beneficial owner changes their address, or has some other change in their personal description, change of passport, maybe, I don't know. That would trigger a filing requirement by the entity. Okay, change of control. Again, I gave you the example where maybe the person had less than 25% to start with, acquired stock later of the company and bumped up against that 25% requirement. It would trigger the filing of a report by the entity. It would also happen if the person started off as 25% or more, and then sold some of their holdings and became less than 25%. That would trigger another change that would where you need to file a report with FinCEN. Okay, next slide. Okay, timely reporting. If you're an entity that was formed before January 1, 2024, then you have to file within 30 days. You file before January 1, 2025. Why such a long time frame? There's no real explanation in the statute or the regulations. If you are formed on or after January 1, 2024, then you have to file within 30 days of creation of the entity. That is the earlier of the date in which the entity receives action notice or the state first provides public notice. In the case of Alaska, when you incorporate almost immediately, there's a notice on the corporation's website, the State of Alaska Division of Corporations website, that the entity is formed, and they actually have an image of the certificate of incorporation. Similar thing for a limited liability company. Okay, safe harbor. If, let's say, you do have if the reporting entity believes its report contains inaccurate information, it has 90 days to correct that information. However, the safe harbor is not available if the person knows some person acts or evades reporting requirements or has actual knowledge that the information reported submitted is inaccurate. That's a lot of words. I hope that's coming across as what's going on here. There are handouts here for those who here of these slides, and you can go back and study them as you think. And also, I would urge you, if you at all feel like you might come afoul of CDA, that you read the statute and read the regulations so that you understand how it fits, how it might affect your particular entity in organization, or if you've just recently organized and are in operation, and you want to make sure that you're square with these provisions. Okay, next slide. Okay, I know you've been all waiting for this. What are the penalties? Well, here's the rub. Willfully providing beneficial information that is false or fraudulent. How do you define that? Well, I think you better believe that the prosecutor is going to define that. And willfully, or if you willfully not providing complete or updated requirement information to FinCEN, consists of, in both cases, civil penalties for liability to the U.S. of not more than $500 per day of the violation, and fines of not more than $10,000, or imprisonment for not more than 2 years, or both. Okay. Now, separate from that is the knowing unauthorized disclosure of or use of beneficial information. It's going to all be in this cloud in the sky. The filings have to be by electronic means with FinCEN. So it's going to be held in this gigantic cloud in the sky. And okay, so if someone that's privy to that information, or somehow gets that information, it will be, and then has unauthorized use of that information, then they're subject to civil penalties similar to above, $500 per day, and fines not more than $250,000, or imprisonment for more than 5 years, or both. But you got to read the red print, small print. If while violating another U.S. law or as a part of the illegal activity involving more than $100,000 in a 12-month period, fines of up to $500,000, 10 years imprisonment, or both. So pretty stiff teeth. That's going to apply to everybody that forms a company by creation, creates a company by filing with a state. Okay, next slide. Okay, so this represents a significant expansion of federal reporting requirements. When I went on in preparing the article I did for the Bar Rag, I tried to get an idea as to, what does this mean in terms of how many people are, how many companies are going to be subject to this? Well, I found one outfit that said that they estimated it would be 30 million existing businesses in the first year would be subject to it, and then thereafter 2 million new businesses each year. So it's a big deal. I mean, it's a big dragnet that's involved here. The form to be used for this reporting, I've mentioned reporting many times, to FinCEN is not provided in CTA, and it's not provided in the regulations. Again, we have less than 6 months to go before you got to file. FinCEN has subsequently proposed for comment a form of the report. It's 15 pages in length, and it's found in the Federal Register as shown there. I've read some of the comments that have come out regarding that form, and there's one that sticks in my mind is one person had said that the form, that in response to several of the questions of the form, you can just simply check unknown, and it undercuts the entire purpose of the act. So I don't know if that's what's holding up the Treasury from adopting the form. It seems like it's taking them a long time since they had proposed this form many months ago. Okay, next slide. Further challenges. Okay, creating the structure and security for the intended data bank by FinCEN. Think about that. In this day and age of the internet, instantaneous access to information, hackers all over the place. I just got to believe that where there's a will, there's a way, and someone's going to hack into that system. And of course, it's from the standpoint of the entity, it's not that. Well, I mean, it's pretty straightforward information that you would probably be able to obtain elsewhere. For instance, on the Division of Corporations website, on each corporation. nevertheless, the information on the beneficial owners is really very personal information. Passport image. I mean, I'm surprised they didn't put fingerprints down too. And they have everybody in the world be in the US to be fingerprinted. This is a real invasion of privacy, I believe. I mean, you got to think about it for yourself as to how you're going to represent this to your clientele, to your prospective investors, if you're looking to raise funds for a startup company or for a recapitalizing a company. Now, there's also an onus on the state regulators of the entities to update their forms and websites and so forth. They have to have a notification of the internet link and the FinCEN and a statement of purpose of the FinCEN form to combat money laundering. I did have contact kind of indirectly with Division of Corporations through the Division of Banking and Securities, and they were aware of the requirement imposed on the state to provide, as this slide shows, and I have not gone back to verify that they've actually have some words on their website, but supposedly they have something that addresses this. Next slide. Okay, the effect on entities generally, in the case of FinCEN, estimated the cost in their proposed regulations to be about $85 per report. The actual cost remains to be seen. Next slide. The effect on Alaska entrepreneurs, I think it's readily apparent. If you're a sole proprietor or Alaska entrepreneur who organizes your business as a corporation or LLC or other business entity with state creation filing required to gain protective shield for personal liability for the business, you immediately become a beneficial owner. You, the person that formed the entity, now are a beneficial owner, and you have to file with the feds. And if you don't file timely, then you're subject to those draconian penalties that I outlined before. Okay, next slide. Okay, so further prudent steps: read the statute, read the regulations. Good luck on your read, and also the reporting format that eventually will be adopted by FinCEN. Thank you.
Outstanding. Outstanding. Such good stuff in here. I dropped my microphone. All right. Very good. Thank you, Julius. And now we are ready to take some questions here. So, anyone have any questions to begin with? All right. Attorney versus attorney.
Practically speaking, this just seemed like no one's ever actually going to enforce this, right? Is this just a RICO hook? Is this just a continuing effort to improve the databases because, passports and the like weren't getting us there?
Is there a question there?
It seems like this is, do we know if this is like another RICO hook so that you can get somebody on the RICO statutes if it's money laundering and this?
Well, ask yourself whether, if you're a money launderer, are you going to try to comply?
That's question number one: is who is this actually going to? Are the money launderers even going to comply?
It's going to affect everybody that has to. It becomes subject to the act, meaning everybody being the probably 99% of the small business operators in Alaska. I'm not saying that there isn't money laundering going on here. As I've given this presentation to different groups, that people will come up to me afterwards and say, you know about this, this going on, or it may be happening around us, but I got to believe that 99% of the legal businesses that legal businesses in Alaska are being handled in a legal fashion, but they're nevertheless going to be subject to this act. They're going to have to file more expense. You're going to have to hire. Well, maybe it's a self-employment thing for lawyers, but you're going to have to hire somebody to advise you. Either that, or you're going to have to read the CTA very carefully and the regulations, and then have to deal with a bureaucracy. And if you run afoul of this thing, then you're going to be hat in hand before a prosecutor trying to argue that you shouldn't be subject to that $500 per day. I mean, that could kill you pretty quickly as a business, I would think.
Yeah, I think, just thinking about my business, I might last like 6 or 7 hours if it were $500 a day. So. Okay, I had a question for you here. Excuse me. When we were talking about, let's see here, I think it was on slide 11, the risks of becoming a beneficial owner. It made me think of all of the conversations that we've seen either here at 1MCups or at other presentations around town where we have a young in tenure entrepreneur, not necessarily in age, that is presenting on their business and potentially looking for investors and things like that. It seems like there's some potential impingements in that prospect that this might interact with. I wonder if you had any thoughts on that.
How about?
So if we had somebody up here that was presenting about their business and part of their ask was that they were seeking investors.
Yeah, now it depends on what you're looking for. If you're the entrepreneur, you're looking for let's say you're doing a crowdfunding issue. There, by definition, you're looking for small investors. You're looking for a large number of small investors. Okay, that can work for some situations. It does have its challenges, but it can work. On the other hand, if you don't want to spend the time to try to get a whole bunch of small people, you're going to have to be beholding to as time goes on in terms of responding to your security holders. Maybe you want to get just a few heavy hitters, some angels. That's where you can run afoul of the statute, because you might bump up against the fact that you have one person that's going to get 25% of the equity and trigger the need to file under CTA.
Yeah. Okay. We have a question here from Demetrios. Says, why is the burden so heavily on small business, but the reporting requirements for large businesses are non-existent?
Well, unfortunately, one of the methods of money laundering, I mentioned or showed you in one of the early slides, 6 methods. But one of them is to take the illicit funds and just to divide a large amount of illicit funds into small packets that are, say, under $10,000 and put them in different accounts of accomplices. So and also you can do this through shell companies that have very little capitalization. So it tends to look, you tend to use entities that are recently formed and small in size, maybe have no real operational history. So they kind of look like those small businesses that are out there legitimately operating. So I suspect that those who were responsible for crafting the CTA as well as the regulations had that in the back of their mind as they were doing it. I mean, it seems like it cries out for an exemption, that for the Secretary of the Treasury to do an exemption that would somehow avoid this trauma to much of private business, legitimate private business.
Excellent. Very good question.
I'll be bold and say this is way over my head. So is this, I'm trying to analyze in the presentation and everything, is this to be proactive of finding the money launderers? And so now it's a requirement for businesses to report their fundings?
Well, that's one theory. If you're a money launderer, would you file with FinCEN? Or would
No.
you just use the illicit funds for another illicit project? I mean, you don't have to. I mean, it depends on what your rationale is. A money launderer is. If you truly want to get money into into the legitimate sector, then you're going to have to find a way to accommodate this FinCEN, because if you avoid it, if you don't file, then you're subject to these pretty stiff fines, 10 years in jail.
Right. So it's having the businesses file with FinCEN regardless if you're a sole proprietor or a corporation, so that way they can be tracking that?
No, sole proprietor, you mean not having a business structure other than you own the business?
Well, at the very end, you said even if you're just a single owner, then you're the benefit?
No, if your business structure requires a filing with the state to create the structure, such as a corporation or a limited liability company or a limited liability partnership, then that satisfies the criteria of the statute for being an entity subject to the act.
Okay.
The next step is whether you have an investor that has 25% interest. If they do, then they are a beneficial owner, and the entity have to file information on the entity as well as the beneficial owner.
Okay. All right. Thank you.
I noticed, this is Alan again, for those of you who can't see me. I also noticed in here, there was the part about if someone ceases to be a beneficial owner. So that requires a reporting
Yes.
too.
Yes.
So if somebody says a 50-50 partner and they divest themselves and say, all right, you can be 100% owner now, I'm out of here, I'm going to Tahiti.
Right. Triggers.
Then there's a
another report.
filing that's required there to let them know that they have exited that business and are no longer exerting their influence or whatever on that.
Yeah, that would trigger a report.
Interesting.
And if you don't file, you got 30 days to file. And if you don't file, then you're beholding to the prosecutor trying to argue your way out of a $500 per day per violation day fine.
So, and we all know,
At best, and maybe at worst, $10,000 and maybe 2 years in jail.
yeah, we all know how timely law enforcement is. So in a situation like that, where you may not know about it for say
That's right.
90 days.
Yeah, they'll
Or it's
add
like
all
all of a
those
sudden-
days in the meantime. Yeah.
Yeah, it's like, oh, surprise, you should have filed this 90 days ago. By the way, here's a nice fat fine of 500 times
Probably- they
900,
probably put
which
you out of
is
business, yeah.
arithmetic. $45,000. I guess it would hit the cap then at that point. That would be the $10,000 cap.
No, it's a fine. It's the
Oh, so that
$500 per
doesn't-
day is to the US. The $10,000 fine, it's not clear as to whether that's supposed to be a cap on the $500 or not.
Oh, wow. Okay, so you could, be in a situation where in that circumstance where say 90 days worth of water has gone under your bridge, you could be facing a $45,000 fee.
Yeah.
And a $10,000 $45,000 fine and a $10,000 fee.
Yeah. Try to
Fees and
explain
fines.
that to your investors.
Yeah, right. And see, it's all very simple. I've got it right here in the book. Okay, another question from Demetrius here says, so ownership changes matter when they're in small businesses, but for massive billion-dollar businesses, ownership shifts don't necessitate reporting because they're already public?
Right. If you're a company that is a reporting company under the Securities Exchange Act of 1934, then you have a free out. That's one of the 23 exemptions. Yeah.
I think that
It's hard to swallow, but that's what it is.
Yeah, I think that's kind of the point that Demetrios is trying to make here. And please correct me if I'm wrong, because I never want to try and speak for somebody erroneously. But they're kind of pointing out that the common person's perception might be that big business is the one that abuses these rules more. And I think that there's kind of something lost in the weeds about the fact that big businesses have to play small to do these games and hide their money and things. And that's why they're putting these rules out there, that it seems like they're making it onerous on small businesses and giving a pass to big businesses. But it's because there's already provisions and things in the law to identify those things in larger companies, and this is kind of filling the gap for smaller ones. I don't know if any of that made sense. You didn't follow
Well,
that?
the larger companies are subject to regulation in other forms as well, on the state and federal level. So it's not as if they got a big total pass. But as far as the CTA is concerned, they get an exemption from this reporting requirement.
Interesting, a follow-up question here somebody asked in how this applies to nonprofits.
That is one of the exemptions.
Okay, so
Yeah,
nonprofits.
but it's a nonprofit that is formed as I think it's a 501c3 with the Internal Revenue Code. It's not sufficient if you just say I'm going to file articles of incorporation with the state of Alaska and get a certificate as a nonprofit. You have to actually satisfy the IRS requirements for a nonprofit as well. Is my understanding of that. I mean, I have given you the view of the requirements of CTA for small business. Keep in mind that there are two other large segments to which it applies, and that is to Indian tribes and to entities, foreign entities that are licensed to do business in the U.S. Now, foreign tribes, for example, or not foreign tribes, I mean, just tribes. If I have it here. Yeah, here. Indian tribes, what does that include? Does it include Alaska Native corporations, for example? The U.S. Supreme Court held in a recent case that Alaska Native corporations are included and Indian tribes for purposes of the Indian Self-Determination Act. Whether they are included for purposes of CTAs, it's not something I'm addressing today.
Okay. Susan, you want to unmute and ask your question, or you can type it and I'll ask it for you?
Sure, I'll unmute. Can you hear me okay?
Yep, we can hear you.
Oh, great. Well, thanks for having us on today again, and thank you for all that information, pretty much on overload. My question is that as a small business startup, so my say I've got a contributor that contributes, say, $100, and my bottom line is like 400. They're 25% of my company. So as I grow, say they don't contribute anymore, do I have to sign them in as as part of that, or is there like a certain amount that you have to have made profited before you have to sign up?
So
Is
make
that a
sure I
lot?
understand the question here, Susan. Thank you for that. Just to make sure I understand the question. So if you have, like, say at the formation of your company, you've got 4 founders, they're all 25% owners, but then say 5 years down the road, 3 of those owners are no longer contributing, you're asking if they still have to report?
Right. As a small business, you're hoping to grow. So at the startup, you've got small contributors or no contributors, or the people say if they contribute 24% of, at what point do they become 25% of your business as contributing if they want to donate to your effort?
How would those people appear on your equity table?
As donors, I guess? Is that, I'm not, yeah. Say they give me $1,000, and it's over 25% of my bottom line. Would they be considered as part of that?
Now, are you receiving this $1,000 as part of any kind of organized money laundering campaign? I'm just kidding.
I really hope not. You never know.
But
I'm just,
Yeah.
I'm just curious, is there like a place where you can go and hire a lawyer for this if you need one?
That is an excellent question, Susan. And I've gone ahead and taken the liberty of putting Mr. Breck's contact information into the chat there, if you'd like to reach out to them. Of course, I would be remiss as a business coach if I didn't recommend always using the rule of 3s. Talk to 3 people before you make your decision to hire a professional. But certainly, I don't think anyone in this conversation would recommend against legal advice in this area.
I could say.
Oh,
one thing.
hold on, Julius would like to
Yeah,
opine as
just
well.
one thing, I could point you to slide 9. That beneficial owner is defined as owns or controls not less than 25% of ownership interest. That doesn't have to be ownership of actual stock or interest in an LLC. It can be some side agreement that you have with the owners of the company or the organizers, that before they do something, they will come back to you and get your approval. For instance, that before they change executive officers, or before they change their board of directors, let's say the person doesn't want to be on the board of directors, doesn't want to be a executive officer, but does want to control them, who you use as them,
Yeah.
as those persons. That could bring you. You said it. Maybe they would donate $1,000. Well, yeah, I think you got an argument there. Maybe it's a true gift, but maybe also it's a hook to influence your
Yeah.
operation. And think about this: you're going to be before a judge or a prosecutor trying to argue your way out of it. If you're talking about significant funds and I don't know. I mean, it's maybe I'm rambling a little bit there, but it just seems like it's prone to be a more difficult question that's going to really turn on the facts. And even if you have the facts right, you're going to still have to argue it before at worst, you're going to have to argue before a bureaucrat back in DC that isn't with FinCEN is hell bent to clean up money laundering.
Well, I appreciate that. Thank you so much. I'll just look back through those slides.
Yeah, excellent question, Susan. Thank you, and Demetrios as well. We always like to finish these presentations, Mr. Brecht, with the question, what can we as an entrepreneurial community do to support you and your mission of getting this information out?
I think you've done that in part already by getting the article out to people. Those who have been on this at this session will certainly take away that information. Just talk about it and just be sure that you understand how CTA and the regulations may apply to your business or your what you contemplate as your business. I mean, you got a lot of other things on your plate if you're an entrepreneur thinking of a startup company and whether it's going to survive muster or not. But you don't want to lose sight of this particular item because it does have some pretty stiff teeth in it.
Absolutely. Well, thank you very much for your time. Everyone, please join me in showing our appreciation. Give us your applause online for Julius Brecht. Thank you so much for spending your time here to help us in the small business community know about this important law that's coming down in just the next 6 months, as you said. All right.
Yes.
This has been here, I can take that from you there. Oh, and I'll
yes.
shake your hand too. I appreciate that very much.
This is the first time we have.
And we appreciate so much your willingness to come out here. So this presentation ran a little bit long today, but this was so important. There was so much good information here. How could we possibly cut that short? So I'd like to ask now if there's any important community announcements that we'd like to share with the community. Please unmute and share those now. All right, if everyone could just speak at once, that would be great. All right, I think we're good. Sounds like everyone's happy with the community announcements of the previous week, so we'll go ahead and move on. If you like this presentation, the conversation doesn't have to end just because we're finished here. Please join us online. Follow us on Facebook, Twitter, YouTube, all of these places where you do your socials. Connect with your community and continue the conversation online. We don't have to end because we're done. If you'd like to get up here and present in the near future, 1MCups.com/present, and you can get yourself scheduled to be right here on this stage at a future edition of 1 Million Cups. We'd like to thank you so much for joining us today. We look forward to seeing you again next Wednesday and every Wednesday morning at 10 a.m. right here at the Emoja Co-working Space in Mountain View, or online on Zoom, Facebook Live, or wherever you consume your online media that we are currently broadcasting it. Look forward to seeing you again next week. Thanks again. Bye-bye.